So now we find the U.S. Supreme Court breathing new life into a major lawsuit against the president's health care plan. Liberty University says the plan violates its religious freedom. And it's got an issue with that mandate as well. Just this week, the Supreme Court said this case should be heard at a lower level. Matt Stavers, the dean of the Liberty University School of Law. Sir, good morning to you. Thank you for your time.
Good morning. Good to be with you.
You know, the court has ruled, I mean, Justice Roberts says the mandate stands. How can you argue today that you can bring a fresh challenge to that mandate?
Well, the fact that the Supreme Court actually granted our motion for rehearing, our petition for rehearing, is huge. It speaks volumes. And obviously, I think there are justices on the U.S. Supreme Court that would want to reconsider this case. And so now we're back on a fast track through the Court of Appeals and back to the United States Supreme Court, probably in 2013. But here's what we have that's different. The issues that we have not been argued before the court before. First of all, the employer mandate across the board for religious and secular employers. We're arguing that that's unconstitutional. But if the Supreme Court were to uphold the employer mandate like it did the individual mandate, the other argument is, and I think this is a significant one, is the free exercise of religion. This has a collision course that's in the making with Obamacare and religion in 2013 when health care policies come up for renewal. And Liberty University, for example, is a Christian university, the largest Christian university in the world. One of the core issues of Liberty University's Christian doctrine is the sanctity of human life, that life begins in the womb and we must protect it. We can't kill the individual children, and we must not be participating in funding abortion. Yet that's what's going to be a collision course in 2013 for Liberty University and for others across this country. That's unique.
Just to put a fine point on it, you're arguing that the mandate that requires you to contribute to the health care law, that money then would be used to cover the cost of abortion. And that is your argument about violating religious freedom. Do I have that right?
In part. In fact, the mandate requires Liberty University and other organizations, religious as well as secular, to provide abortion coverage or abortion-inducing drugs. Liberty University doesn't do that now, and that's a line that we cannot and will not cross. That's the collision that's coming in 2013. And I think the Supreme Court shows an interest by the fact that they allowed this to continue. In fact, in the last term, the Supreme Court issued a 9-0 decision in favor of the free exercise of religion, rejecting the Department of Justice's position that ought to be very limited. They have a very expansive position on this issue, and the fact that they've done that in the last term and they now breathe new life in this case, I think shows that there's an interest in ultimately addressing this case. We are headed toward a collision in 2013.
Yeah, why do you believe the court made that ruling?
Well, you know, it's
why did it come out and say, listen, you should have your case heard? And the follow-up to that is pretty obvious. Where were you during the original challenge on this case?
Well, we were actually at the original challenge. In fact, Liberty University and private individuals, Liberty Counsel, filed the suit back in March of 2010. So we were the very first private lawsuit in the country. I argued at the District Court and at the Federal Court of Appeals. And in 2011, the Court of Appeals didn't address our merits of the case. They ultimately ruled that the Anti-Injunction Act prohibited them from getting to the merits. We asked the Supreme Court to review that matter, and Liberty's case was the very first day of the 3 days of oral argument on the Anti-Injunction Act. So when the court ultimately made its ruling, it ruled in our favor, and that's where we are now, breathing new life into this case, having the rehearing, directing the Court of Appeals to now address our issues. If the court thought that there was no merit in our issues, or if they simply did not want to be bothered by Obamacare again, they could have easily denied our petition for rehearing, but they granted it.
It'll be interesting to follow. We'll see whether or not it has success of going back before the justices. You're saying the end of 2013 is something we'll watch, sir. Thank you. Matt Staver, Liberty University. Thank you for your time today. Just about 10:30 here in New York. Here's Martha.